Welcome back to my YouTube channel, VaJee Law, a center for legal excellence. In the series of IBC Amendment Act 2016, I am dealing what is amended in Section 16. Okay, what the position earlier is that if a financial creditor files a Section 7 petition, okay, he proposes a resolution professional along with the petition, and adjudicating authority sees that if RP has valid AFA and there is no disciplinary proceeding pending against him, the RP appointed as the IRP is appointed by the adjudicating authority from the petition itself. Means creditor has a right to propose a interim resolution professional in the case of when the petition get admitted. Okay. Now, Section 16, after the 2026 amendment, what happens? That if a corporate debtor files an application under Section 10, it means corporate debtor coming himself to declare him insolvent. Then they can propose a resolution professional earlier, but now adjudicating authority has to appoint a interim resolution professional from the panel, which is recommended by IBBI. Okay, and the board recommends the name as per the section 16 section 4, and then adjudicating authority appoints such interim resolution professional in the case of admission of that particular corporate debtor under section 10. This is the major change that is introduced by 2026 amendment. Earlier, what happened when and for the procedural alignment, the incidental and necessary changes are also made. What happened? Say suppose if a operational creditor files an application petition under section 9, so existing provision of section 16 subclause 3 says that adjudicating authority has to appoint the interim resolution professional from the recommendation of IBBI, and that IBBI has to give name within 10 days. Within 10 days. And same is the position now in section 10. Okay. In section 10, adjudicating authority must refer the matter to the board, and within 10 days board must recommend a professional within 10 days, and the recommended professional must be one against no disciplinary proceeding pending and he is holding a valid AFA. Obviously, when IBBI recommending someone, this is the basic that the IBBI check, and there is a we are using the formal procedure like adjudicating authority had to refer to IBBI under section 16 subclause 4 for the purpose of section 10 petition, and they have to refer back and give a name within the period of 10 days. But for the smoother proceedings, what IBBI did, they generally give a panel list. They prepare a panel in which all IPs are enrolled in Delhi, based in Delhi, are listed out and sent it to NCLT. And NCLT then according to the codes, the names of the IPs are divided, and then adjudicating authority has to appoint IPs from those panel. Okay, and for the consistency with section 10, uh, 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 consistency with the section 10 omission. The word section 3B, which allows the corporate debtor to propose a RP, has been omitted because we in section 16 we amended that. Adjudicating authority has to refer to IBBI for the purpose of appointing IRP. Okay, and, and that is a summary that I have provided in a nutshell for the whole section 16. And I can perceive it, it's a neutral start, fair process, and a strong resolution. Because when a corporate debtor coming himself that declaring insolvent, and he coming with a professional who regulate a process, that can be seen just that he might be his man. That that is not true, but some creditors can perceive like this. To avoid those conflicting situations, this amendment is introduced. Neutral start, fair process, and a strong resolution. This is a particular reform that reinforces the trust in the IBC framework and promotes a healthy credit system. I hope I'm explaining this section. I am hoping that I bring more clarity. Thank you.